Hello and welcome to Property Money Trees Maximising Property Values, the once a month show where I break down the steps of how to recognise, enhance, and then extract the values in property in order to create wealth. Would you like to find out how you can benefit from the steps of maximising property values? This is even if you don't own a property yet or have a deposit. If that's a yes, then you're in the right place to find out. My name is Patricia Ogunfaber, and although many know me for my work as a solicitor, on this show you will be getting the benefit of my 30 plus years worth of experience of maximising property values, experience which has given me a net worth in millions. So who might benefit from listening to this show? Literally anyone with an interest in creating property wealth. Welcome back. So as I promised last month, I am moving on to the introduction of my book, Be Prepared, Renters' Rights and Residential Landlords in England. Introduction, why I've written this book. This work is to make landlords aware of the coming changes to the private rented sector in England. There's no denying that radical reform of the sector is required, and the Renters' Rights Bill 2024, the bill, proposes to achieve this by introducing completely new law while also amending 29 other Acts of Parliament. Landlord legislation will be even more vast, and I have little doubt that the new law will generate a fair amount of litigation requiring the input of higher courts. Landlords being able to avoid being litigants is one of my aims of writing this book. Another is for landlords to avoid the potential crippling fines. Tenancy reform. The proposals intend to radically change the private rented sector, and these aims will be implemented through legislation in 2025 when the bill will become the Renters' Rights Act 2025 after it has passed through Parliament, the House of Lords, and received royal assent. It is worth noting that the law will, however, only apply to tenancies that are assured tenancies. There's more on this in Chapter 1. While the bill is currently a set of proposals, it is likely that most of it will become law because the Labour Party has a sufficient majority to make sure it does, and this is the reason why it is important that landlords understand what the main changes will be and prepare themselves accordingly before the bill becomes law. I have found some of the bill's proposals to be excellent. In particular, the outlawing of discrimination, but some of the proposals and the general tenor of the bill cause me concern, possibly because as a solicitor, albeit now non-practicing, my default way of addressing any potential issue is to seek to understand the worst that can happen and then find ways to guard against any perceived potential calamity. What if? The worst that can happen with some of the clauses in the bill could be financially devastating if a responsible landlord is unfortunate enough to have a tenant who wishes to manipulate the law either out of spite or financial motivation, and or B, to deal with a heavy-handed, ignorant local housing authority or county council. Although, as I've said, I start with a worst case and then assess, so don't panic too much. I'm simply looking at some of the worst case possibilities. But what if this happens to you, a responsible landlord? Nevertheless, consider these two examples of tenants trying to game the system. Sadly, it happens. 1. An attempt to claim rent repayment and therefore live rent-free for 12 months. A house was let to 4 sharers and therefore did not require a mandatory HMO licence. The tenants then took in a 5th person, making the dwelling licensable. When the landlord's agent went around for an inspection, he noticed that the spare room looked lived in and queried the tenants. They said that no one was living in the room and that one of them had had a stayover guest. A few months later, the tenants reported the landlord to the local housing authority for letting out an HMO without a licence, an offence that at the time carried up to £30,000 fine and a potential rent repayment order of up to 12 months' rent. The local housing authority inspected the dwelling, saw that 5 people were indeed living there, and asked the landlord to make the dwelling HMO compliant within 28 days. The landlord couldn't finish the works within the given time and, unknown to the tenants, agreed to a time extension with the local housing authority. As soon as the first deadline expired, the tenants applied to the first tier tribunal, Property Chamber, for a rent repayment order for the previous 12 months. The agent's evidence, together with the fact that the landlord had obtained an extension within which to complete the works, won the day for that landlord regarding the rent repayment order, but it could have gone disastrously wrong for that landlord. Number 2, a ruse to live rent-free for as long as the possession process took. The tenant didn't pay rent for 2 months. The landlord sought possession on the basis that the tenant was in serious rent arrears, ground 8. The tenant then claimed various issues with the building, which is untrue because I know the landlord, who is very honest, and he said that wasn't the case. The judge believed the tenant and refused to grant the landlord possession 8 months after the possession was first claimed. What if a tenant complains to your local housing authority that you, during a conversation, that happened, asked them to leave your property? A lie. What if a tenant clogs up their plumbing such that it overflows and smells and doesn't open the windows for ventilation and maybe breaks a few windows to boot and then reports you to your local housing authority? What if a prospective tenant says you refuse to let to them because they're on benefits and have a child? What if your local housing authority is not geared up to dealing with the new law properly? I know landlords who are patting their backs, telling themselves that they are responsible landlords and that not much, in real terms, will be changing, and that if they do A, B and C, they'll be fine. I hope so. Both examples above are about tenants who were fully referenced before the letting started. While I know that most tenants are not like the ones in the above examples, the examples might not simply be exceptions to the rule. So to discount that or something similar happening to anyone might be unacceptably naive. A crucial aspect of the bill is that local housing authorities will now have a duty to enforce landlord legislation and will be effectively funded to do so. This will be a complete game changer. County councils without a local housing authority may also do so, but won't have to if they don't want to, because they won't have a duty to enforce. The law and this duty could therefore mean the end to many cash-strapped local housing authorities' financial woes. I set out some of my concerns in this area in my response to Parliament's call for evidence regarding the bill, which can be found on Parliament's website. I therefore believe that because of the proposals, there will be more landlord court cases, either as respondent/defendant or as applicant/claimant. And landlords may therefore need to build a legal war chest to ensure financial survival in the coming era. I am sharing my thought processes regarding the incoming law and hope that they help some responsible residential landlords in England, as these are my sole focus. Apologies to colleagues in Wales and Scotland. Careless/rogue landlords will need to shape up or ship out, as there will be no place for such in the coming era. Please note that this book is not an exhaustive work. It is simply being produced to enlighten and hopefully raise some money for my favourite charity, Centrepoint. All sales receipts will go to Centrepoint so that it can continue its amazing work in keeping homeless youths safe. My methodology. To make this book easier to digest, I introduce each section briefly and then set out some important changes to note in orange bullet points. When called for, I set out the main consequences of non-compliance in gold brown, and then tips on how to mitigate, if not eradicate, potential risks in green. This book is therefore best read on Kindle apps, phones and tablets, and not on Kindle devices themselves, as they can only display text in grayscale. To better understand the appeal process of penalties, fines, etc., readers may wish to have a look at Appendix 1, where I've set out a diagram of the different stages of challenging a fine/penalty up to the first-tier tribunal property chamber. Next month, I shall read the next part of the book, which is titled Always Ask This Question. When might the proposed law not apply? Hopefully, see you then.